Welcome to How the EU GDPR May Affect Your Website from SilverTech. We are a digital agency working to redefine how businesses engage with and understand their customers.
I'm your host, Ian Hughes, content strategist here at SilverTech. I write for SilverTech's blog, podcast, and our webinars, and I'm pleased to introduce SilverTech's GDPR experts. They both bring a unique perspective to the issue. And first, let me introduce Paul Cream, Vice President General Counsel. With over 30 years of experience practicing law, Paul works with senior leadership to ensure that SilverTech is consistently pursuing strategic goals as well as providing day-to-day contact review. Welcome, Paul.
Good morning. Thanks for having me.
Also joining us today is our Chief Technical Officer, Derek Barca. Derek, as the Chief Technical Officer at SilverTech, leads the team that helps businesses create profitable relationships throughout the entire customer lifecycle. Welcome, Derek.
Thank you. Good morning, everyone.
Before we dive into GDPR, just a quick reminder of who we are. We are SilverTech, a digital marketing agency and technology company. We've been in the digital space since 1996. We have more than 100 crew members engaged in more than 500 active projects across a variety of industries. Our goal is to redefine how organizations understand their audience and the entire customer journey. We do so with intuitive design and a seamless sharing of data across the main marketing technology platforms, your content management system, marketing automation platform, and CRM. On the agenda today, we're going to give some background and introduce the European Union General Data Protection Regulation, that's the EU-GDPR or GDPR. We review a glossary of terms and review some of the key provisions. We'll give some examples of how companies in the US are complying with the law before opening things up for questions. Part 1, Intro to the EU-GDPR. Well, how did we get here? In 2009, a Spanish man, Mario Costello Gonzalez, took Google to court over the right to be forgotten. He had found that when he Googled himself, a story about the forced sale of his home in the 1990s kept appearing in the search results. He had long moved on from the story and felt he should have the right to delink it from his name. He reached out to Google and asked them to do just that, but they ignored his request. As a European citizen, he had no way to compel the American company to act on this request, but he had an ally in Spain's data protection agency. Together they waged a legal battle that lasted 5 years, but ultimately resulted in a landmark European court ruling against Google. That ruling backed Gonzalez's assertion that he had the right to be forgotten, and that upon request, Google should have to delink the embarrassing articles related to his name. This preempted and certainly influenced negotiations that were already underway within the EU over a sweeping new data protective directive. The negotiations and directive became what we now refer to as the European Union General Data Protection Regulation, EU-GDPR or GDPR, approved in April of 2016 and effective as of May 25th this year, 2018. The GDPR is a far-reaching and complex set of protections that embodies 99 articles across 88 pages. Well, the purpose of the GDPR, it replaces the Data Protection Directive 9546/EC as stated on the GDP portal. The purpose is to harmonize data privacy laws across Europe to protect and empower all European Union citizens' data privacy and to reshape the way organizations across the region approach data privacy. Paul, the GDPR gives a broad definition of personal data, and it goes much further than what we here in the US would typically consider to be personal data. Could you explain what's included?
Certainly. For the most part in this country, we identify personal data as your social security number, your name, and that's really pretty much about it. Maybe driver's license numbers, things like
Sure.
that. This particular regulation goes beyond that and is actually a natural evolution of how they treat it in Europe in general anyway, which is personal information can be IP addresses, photos, social media postings, IP address, in addition to what we identify as personal information, which is social security numbers, your name, and your address.
So it is really a difference in culture almost in that Europe now sees these items as personal and protected data.
That's correct.
Now, your company may think it does not have to worry about this because you are located in the United States, and you may be wrong. If your company processes or holds data for a person residing in a European Union country, your company will have to comply. Here's insight from John Keppins, the president of the DRI. He shared an example in a recent statement. He said, let's say a mom-and-pop bookstore in Ohio sells a single book to a customer in France. By virtue of collecting payment information, the bookstore is now required to abide by the extensive and onerous requirements of the GDPR. I have to say I've never seen anything like it, he says. Failure to comply with these potentially onerous requirements could cost companies, and we have it up on the screen there, $25 million or 4% of global annual revenue, whichever is greater. Paul, is there any likelihood that this mom-and-pop bookstore would be fined?
Well, I guess you could say maybe not that likely, but on the other hand, I don't know why you would want to take the chance necessarily when to do these things is going to be relatively easily done, which is redo your privacy policy to make sure that you're being compliant. And obviously, again, if you're a smaller entity, knowing where data is kept is not as difficult as if you are a huge multinational, multi-billion-dollar company to figure out where things are kept. And then obviously, if you have a data breach, the obligation to notice is there, and it would be anyway. So even though the likelihood of being tagged is probably relatively low, I guess I'm not quite sure why you would necessarily not want to at least think about it.
At least take those steps that you outlined there. We'll cover exactly who will have to comply with the law shortly, but before we do, it's worth noting that the stated goal of the GDPR is to curb marketing's insatiable appetite for data and put consumers back in control of how and when their personal data is collected, used, shared, and monetized. And though it's tempting to write off the GDPR as bureaucratic overreach, many, including Mauricio Paez, head of security for Jones Day in New York, see it as the next significant evolution in privacy protection and not as an incredibly burdensome imposition. Derek, often when we engage with a client who's looking to add advanced personalization to their website, much of the work is about identifying the right data sets, collecting the right data. If you were working with a hypothetical client in Europe, or one in the US is doing business in Europe, do you think that the GDPR limits your ability to personalize and use the right data?
I don't think it does. When we look at doing personalization on the web or in marketing automation and emails and things like that, there's a couple different sets of data we look at. First and most simple is behavioral data. So if someone's browsing a website, we're looking at, okay, what type of content are they consuming? What conversions are they doing? What links are they clicking? What types of products and offers are they looking at? And then based upon their behaviors on the site, we might put them into a segment or persona and then start to drive different offers based upon what we know about them from their behaviors. As we're doing this, we're not collecting any of that personal information on them. We don't know what we might know what their IP address is, but we're not saving it. We don't know what their name is. We don't know what their email address is because they haven't engaged with us yet. We're just looking at their behaviors on the site and personalizing based on that. That wouldn't be affected by this at all. The second type of personalization is what we call first-party data. So first-party data is the data that you, the company, have on someone. So now they've either engaged with you through downloading something from watching a webinar maybe.
Right,
They gave us their email address, watching a webinar. Maybe they downloaded a white paper, or maybe they're an actual customer. So now we actually have information on them. And we're starting to personalize based upon maybe previous products that they've engaged with. Maybe we know if they've watched the GDPR webinar, so now we're showing offers on the website based upon that. That type of stuff would be impacted, but again, the person would have to request to be forgotten. I don't see people engaging with a brand, whether it's through sales or marketing, and then immediately requesting to be forgotten.
Sure.
So unless they do, we can still use this data to market to them and personalize them to them. The third type of data we use for personalization is what's called third-party data. So it's not our data. It's data we're either buying, so it could be lists and emails and things like that, which I think we'll talk about a little bit later. But it might be segment information based upon advertisements and things like that. So not a lot of people know this, but when you do advertisements through even things like Facebook or any of those things, you can buy information about the site visitor. But again, it's not personally identifiable.
Sure.
It's that behavior type stuff. So if I'm a bank, I could say, okay, I want segment information on my visitors. Are they going to auto loan companies? Are they looking at cars online? Are they looking at Zillow and mortgages and stuff like that? And if they are, I know they're maybe in the market for a loan. I can start to personalize loan information for them. But again, we're not talking about personally identifiable information. So
Sure.
it's still stuff we can use, and it wouldn't really, GDPR is not going to affect that.
Okay, excellent. Thank you. Here in the United States, where the use of personal data is governed by several different entities, including the FTC, Health and Human Services, and state by state on a unique basis, it's unlikely that we'll ever see this type of single unifying data protection framework like that in the GDPR. However, recent public interest in privacy breaches, there's Cambridge Analytica scandal that brought Facebook before Congress, we may see a push to put more privacy protections in the hands of consumers. And it's likely the guiding framework is going to be the most wide-ranging of those, the GDPR. So we'll have to see what happens after May 25th as this goes into effect. Let's now dive into some of the glossary of terms and the key principles of the GDPR. We'll start alphabetically here and go through. Breaches. Under the EU GDPR, notice of a breach is mandatory and must be done within 72 hours of having first become aware of the breach. Data processors will also be required to notify their customers, the controllers, without undue delay after first becoming aware of a data breach. Derek, this is a provision of the GDPR that has caused some concern. How difficult is it to identify a breach and then notify affected parties within the first 72 hours?
I think this is going to be where the real challenges lie. 72 hours isn't a lot of time to identify what happened, how it happened, and then remedy the security flaw. If an organization has a data breach, in all fairness, their first instinct isn't to let people know. It's to identify what happened, how it happened, and then fix the problem so there isn't another breach. So that's going to be the first course of business.
Sure.
Doing that and then identifying who has been breached and going out and obviously letting them know. Doing all that in 72 hours is going to be extremely difficult. That being said, the intent behind the law is obviously a good one.
Right.
You don't want situations where, like Equifax,
Yeah.
The last year or so, sat on a breach for weeks or months at a time. So I think having to alert consumers that there's been a breach promptly is a good thing. I think 72 hours is going to be a big challenge.
It'd be a big challenge to turn it around that quickly. Another important term from the GDPR is the conditions for consent. Now, the conditions for consent have been strengthened, as companies will no longer be able to use long, illegible terms and conditions full of legalese. Consent must be clear and distinguishable from other matters and provided in an intelligible and easily accessible form, using clear and plain language. It must be as easy to withdraw consent as it is to give it. Explicit consent is required only for processing sensitive personal data. In this context, nothing short of opt-in. Paul, can you give an example of how companies can make their conditions for consent clearer? Does there need to be opt-in pages, pop-ups on every
probably
page?
the best practice
Yeah.
to do that. I think another way to do it is obviously require people to scroll all the way to the bottom of a page before they can accept terms and conditions, and in those terms and conditions, the consent should be clearly stated as to what it means. Also, it needs to be clearly stated that you have a right to be forgotten. In other words, to revoke your consent, theoretically.
Okay, yeah.
So I think as long as you have a privacy policy that states those things, and then you have a process in which people are taking a proactive step to opt in, you're probably in a much better position to take the position that you have required consent in a clear and unambiguous way.
Okay, sounds easy enough. Data controller, data processor, data subject. So from Article 4 of the GDPR, the controller means the natural or legal person, public authority, agency, or other body which, alone or jointly with others, determines the purposes and means of processing of personal data. Then there's the data processor. Processor means a natural or legal person, public authority, agency, or other body which processes personal data on behalf of the controller. And then there's the data subject, and that's the natural person or individuals covered and protected by the EU GDPR. So if Company A collects email addresses from a data subject or consumer on its website for the purpose of marketing, and uses a marketing automation platform managed by Company B to store those addresses and send emails, Company A is the controller, and Company B is the processor. And it's possible for a company to be both a processor and a controller. For example, it's likely that Company B also collects email addresses and uses personal information to market its services. Previous data regulations had placed much of the burden to comply on the controller. GDPR makes the controller and its processors, as well as any sub-processors, called other processors, mutually liable for the violations. This shared responsibility will likely affect how controllers and processors select, vet, and contract with each other. How exactly this relationship will change, like many of the provisions, remains to be seen, and we'll discuss this a little further. Data portability. So GDPR introduces the concept of data portability. This is the right for a data subject to receive the personal data concerning them, which they have previously provided in a commonly used and machine-readable format, and have the right to transmit that data to another controller. Derek, here's another part of the GDPR that's causing some consternation. The right to transmit data to another controller. How are companies going to do that and do it securely? Do we know yet?
I don't think there's going to be any specific methodology for doing it, at least not right off the bat. But again, I don't think this is cause for concern or anything. We transmit data securely every day.
Sure.
You can do that through things like secure FTP, secure email. We're just setting up a secure connection between two different companies. Again, I think what's going to happen here is we're going to kind of wait to see how this plays out. If we see this happening over and over and over again, I think you're going to start to see these data platforms making it easier to share data securely. But In the meantime, I think it's going to be more of a manual process and just kind of doing it the way we've been doing it today. I don't see anyone jumping up and making this more complicated than it needs to be.
Sounds good. Data protection officers. So your company will be required to maintain internal records and appoint a data protection officer, DPO. If one of your company's core activities consists of processing operations which require regular and systematic monitoring of data subjects on a large scale, or of special categories of data, or data relating to criminal convictions and offenses. Paul, do companies have to specifically hire for this role, or say, can your current compliance officer be given this as a dual role?
No, I don't think you need to hire somebody specifically to do this, especially, obviously, first of all, there's certain companies that are affected, so they're going to tend to be larger anyway.
Yeah.
But secondly, as long as the person who has responsibility for this is not in a position where they have a conflict in maintaining this role with some other role in the company, that is going to be fine as well.
Okay.
In other words, you might not want to have your marketing director be
Sure.
your DPO, but you might want to have your IT person do it, or you might want to have your lawyer do it, or you might want to have, somebody in finance even could be in that position of requiring compliance.
Mm-hmm. Yep, makes sense then to not have the marketing
Yeah.
manager necessarily
Yeah.
honor that dual role. Right to access is another key term. Each person covered has the right to obtain from the data controller confirmation as to whether or not personal data concerning them is being processed, where and for what purpose. Further, the controller shall provide a copy of the personal data free of charge in an electronic format. And we also have the right to be forgotten. Each covered person has the right to have the data controller erase their personal data, cease further dissemination of the data, and potentially have third parties halt processing of the data. Derek, how are companies going to process right to be forgotten requests? If one came to you today, how would you know you could fulfill that request and erase everything?
Yeah, no, absolutely. So we've been already working with clients on how to kind of approach this today. And again, it doesn't have to be overcomplicated.
Right.
What we're recommending and working with people on is the first thing you need to do is create a data inventory. So we have a template. We use a spreadsheet to do it. We go through and we create an inventory of all the places you're storing data on, customers, prospects, leads, and things like that, and then have it inventoried. Then what we're doing is just drafting, procedures on, okay, so if someone comes in and says, I want a copy of my data, how would you go about getting that data and providing it to them? And then procedures on if someone has to be forgotten, how would you go about removing them from the systems? That's the key piece, because sometimes you're not going to delete all the data. If you're an organization that does retail sales and things like that, you can't delete your record of the sale that occurred.
Yeah.
You can't delete the order. So it has to be a way of scrubbing the personal information and leaving the order there and things like that. So again, you don't have to overcomplicate it now, but at least have some procedures and policies in place to identify where the data is and what you're going to do should you get a request. That way, if it does happen, you know how to respond. You're not kind of caught flat-footed.
Nice. And Derek references an inventory there. We do have a template that we'll be sharing in the follow-up to today's webinar to help you get started in that respect. The key principle, or the guiding principle of the GDPR, is that natural persons should have control of their own personal data. And it extends that control to each of the 508 million individuals in the European Union, which includes the countries on your screen there. I won't read through all of them. Important to note, though, that I'm sure you've heard of Brexit and the likelihood that the UK is leaving the European Union. That will not pull them out of the GDPR necessarily. Legislative bodies there are working to incorporate GDPR standards into UK law. So expect to see a continuation of that if and when the UK does remove itself from the European Union. So as discussed earlier, if your company processes or holds personal data for a person residing in one of these countries, your company will have to comply with the GDPR. Now, it's important to note that, say, an Austrian citizen travels to the United States, accesses your website, and makes a purchase here. You are not responsible for complying with the law in that regard. The law only covers EU citizens who are in the EU when their data is collected. Further, EU citizens would have to be a target of your company's marketing in order for their data to be protected. So if that same Austrian citizen uses Google for an internet search and comes across your website, which is written for American consumers or B2B consumers here, then their data would not be protected. However, if your webpage was written in Austrian or mentioned other EU users, then it would be considered targeted marketing and thus covered by the GDPR. So to state it more succinctly, really, the GDPR applies to any organization, commercial or otherwise, that A, offers goods or services to EU residents, or B, monitors their behavior. Derek, Paul, I'll open it up to both of you. Can you think of any industries or types of companies in the US that should be paying close attention to the GDPR?
Yeah, absolutely. So some of the ones, obviously you have the retail customers. I think that's the most obvious one. Some of the ones you might not think of that come to my mind because we've been working with them closely lately are first and foremost tourism. So travel
Sure,
and
of
tourism
course.
clients. A lot of times travel and tourism industries are targeting people in the EU.
Yep.
They're providing travel guides to download. They're providing marketing on top of that. So that's going to be a key one because there's going to be a lot of customers there. The second one is higher education. Obviously, universities here in the States are targeting students in the EU. They're asking them for information. They're asking them to fill out applications, things like that. So they need to be prepared to delete those applications or remove data should it be requested.
Should the request come through? Yeah.
I think in general, any entity that is doing transactional things through their website would have to think about it, because if you're transacting any kind of business, whether it's selling of services, hospitals, for instance, could even be
Sure,
included.
absolutely.
Where you're not only transacting information and asking people to transact through your website or your portal, but then you might be then processing credit card payments, things like that. So you may not be a controller, but you may be a controller who's then passing that obligation onto the processor. So I think just about anybody that is interacting with public through their website portals and their website's not more of a static advertisement type portal,
Right.
they need to be thinking about it.
Yep. We'll go over at a minimum some of the things that you should be thinking about just as we wrap up the presentation. Not drastic measures, I don't think you have to take, but it does seem that it's likely that everyone should be aware and consider. So before we consider how some companies in the U.S. are working to comply with the law, let's review the key principles. So principles relating to the processing of personal data. Personal data shall be processed lawfully, fairly, and in a transparent manner, collected for specified, explicit, and legitimate purposes, and not further processed in a manner that is incompatible with those purposes, adequate, relevant, and limited to what's necessary in relation to the purposes for which they are processed, accurate, and where necessary kept up to date. Paul, as we look at these expanded protections for personal data, there seems to be a risk in perhaps even inadvertently violating these protections. I can think of the provision at the end there where it has to be accurate and where necessary kept up to date. Do you see any trouble there?
Well, I think that obviously you're not going to be nailed or caught unless you actually have a breach or you don't fulfill someone's right to be forgotten. But again, that doesn't mean you shouldn't try to be as careful as possible. I don't think the regulations have an intent provision in there, so unfortunately, you don't need to have a bad intent to be in violation.
Okay, yeah.
But on the other hand, I think if in fact you have a violation and you make your best efforts to promptly notify people of a breach or to fulfill a right to be forgotten to the best of your ability, that certainly is going to help possibly in defending a claim that may or may not come down the road.
Interesting, thank you. Further, individuals have the right to access, erase, and correct errors in their personal data, object to processing of the data, ask an organization to export their data, and even directly to a competitor. So conditions for consent, where processing is based on consent, the controller should be able to demonstrate that the data subject has consented to processing of his or her personal data, and the data subject shall have the right, as we've talked about, to withdraw his or her consent at any time. In other words, companies or data controllers must provide clear notice and purpose of data collection, obtain consent for processing of data, define data retention and deletion policies. And Paul, we've recently updated our privacy policy on SilverTech.com. Can you share some of the changes that you made?
Well, I think the big thing that we did here was to make sure our consent provision was clear and and was unambiguous. And again, we're not transacting a lot of things through our website, so some of the things that other companies may have to think about in more detail weren't quite as much of a concern for us. So for us, it was probably more just make sure our privacy policy was updated to make sure consent's clear and added in the language about your right to be forgotten and to withdraw consent, or what we did for our website. But again, if you're transacting more things through your website, you may have to be a little more complex in how you're going to update your privacy policies to meet your business requirements.
Absolutely, makes sense there. Let's discuss now how companies are complying in the U.S. This really brings our story full circle back to that of Mr. Gonzalez and his request to be forgotten. You probably thought to yourself, as we're going along here, how were search engines and social media networks going to comply search engines and social networks clearly fall into the category of being both data processors and data controllers, as they gather and collect personal data and then allow other data controllers to use that data for targeted advertising. Clearly, too, both Google and Facebook, the big ones, operate in the EU and will have to comply with the GDPR. Here's Facebook's statement regarding its commitment and preparation for GDPR. Data protection is central to the Facebook companies. We comply with current EU data protection law and will comply with the GDPR. Our GDPR preparations are well underway, supported by the largest cross-functional team in Facebook's history, and we're also expanding our Dublin-led data protection team, which is leading these efforts. Which brings us to advertising on Facebook. So if your company advertises on Facebook, you may be concerned that Facebook's general compliance may hinder your efforts. And here's Facebook's response to that matter. Businesses who advertise with the Facebook companies can continue to use Facebook platforms and solutions in the same way that they do today. Each company is responsible for ensuring their own compliance with the GDPR, just as they are responsible for compliance with the laws that apply to them today. Facebook rightly points out that if you're advertising on their platform, you become a data controller, and therefore you must comply with GDPR if you're targeting users within the EU. Derek, you may have noticed updated terms and conditions on various social media accounts. How well do you think social media companies will do in complying, and will it affect their advertising business?
I don't think it's going to affect our advertising business. The marketing today, the web today is kind of built on all of this, and I think consumers understand that, and it's the way things are done. But Facebook is correct. If you're advertising on their platform, you're going to be receiving personal information about the people you're targeting, and now you're responsible for that information. You need a way to remove it. I'd even take it a step further. What you see a lot of times too is beyond advertising, a lot of websites have single sign-on integrations with things like Facebook and Google and stuff like that for their own site. When you create a single sign-on, you're receiving personal data. It could be their name, it could be their email address, it could be, their hometown, location, things like that. Any data that Facebook might have on that person can be now transmitted to you. Obviously, if they approve it when they do the single sign-on. But now you have to comply with this law and be ready to delete that data should someone request it.
Interesting. Yeah. So what does this all mean? As the courts work to elucidate the more vague or subjective aspects of the law, it's clear that your website must contain notices to all users as to what data you collect, what you do with the collected data, and how it's protected. Consent reforms need to be reviewed and, if necessary, updated to clearly reflect that the granting of consent is unambiguous, as Paul has said, and that the user understands the terms of the consent and that it can be withdrawn. An internal discussion should occur to make sure that the relevant people in your organization understand what EU GDPR is and what's needed to be in compliance. Email marketing. Here's a specific change. As all email lists of persons covered will be impacted by the GDPR, that means you will have to be able to show proof of compliance and a process for email recipients to opt in or out of your email communications for all out-of-date, current, and future email lists. It may be time to delete or purge any out-of-date or previously purchased lists, as confirming consent may prove difficult. GDPR also presents an opportunity for email marketers to reconnect with their database, but all re-engagement emails will have to disclose the following: why the company is contacting them, how the company initially acquired their personal details, how to update communication preferences or opt out of further communication, and what the value the recipient of the email will receive for opting in. Ahead of the GDPR live date, there are some companies that just went ahead and deleted their entire email database. You can see on the right side of your screen an example of such an email from the UK pub chain, JD Wetherspoon. Derek, thoughts on companies taking such measures? Should they consider just deleting their entire database before May 25th?
I think that's probably a little extreme.
Yeah.
I'd recommend probably just reevaluating your lists.
Yep.
Again, doing an inventory, looking at your lists. Obviously, if you have lists that are 5 years old and you haven't engaged with that user in a long time, maybe you look at deleting those segments of users. But obviously, if you have customers, they've already engaged with you and they've given consent. If you have lists of emails that you've sent out and the person again is engaged with you again, I think that is showing that they're a person that wants to be part of your marketing.
Mm-hmm.
I think the change we're going to see here in the future, and I haven't seen it happen yet, but today, obviously, any email that goes out has to have a means for the person unsubscribing.
Yeah.
I could see in the near future, as this becomes more and more common, there might be a way to there might be a forget me link.
Yeah.
So you might see some of the bigger marketing automation companies start to add that functionality right into their site, where people can unsubscribe or completely forget me.
Mm-hmm.
I think that's probably the evolution we're going to see, but I don't think people have to start throwing away the list or anything like that.
Right. I think, Paul, you brought up a good point about one of the dangers of throwing away all of your lists and starting over yesterday. But could you share?
Yeah, well, I think the danger of just arbitrarily deleting things if it's not part of your normal process of purging your system is if to be able to recover something if in fact you need to defend yourself.
Mm-hmm.
I think that's probably a mistake to just arbitrarily start deleting emails and information from your system, because then if somebody comes in and says, now you need to validate something and you can't do it and you've done it outside the ordinary course of your normal process, then it doesn't look that good.
Right. How can you prove that you've actually done it if it's no process there? Changes to forms and cookies, the conditions for consent, will affect how website and landing page forms are filled out. For example, it will no longer be acceptable for forms to include pre-checked boxes. For using cookies and remarketing, visitors must be able to easily opt out of cookie tracking for each individual use. Here from our partners at Kentico, you can see an example of a pre-GDPR form on the left and one that will be compliant on the right after May 25th. Notice that the conditions for consent are clear and check boxes are not pre-checked. As we wrap things up, let's get into, kind of at a minimum, what you should consider. Well, you need to make sure that you have a privacy policy that states that the site uses cookies to track activity, if that's the case, and provide an enhanced user experience. It should also be clear that the user can choose to disable cookies in their browser if they're concerned. If requested, you need to be able to provide a copy of any data you have on a visitor. And if requested, you need to be able to erase any data you have on a visitor. The other thing we recommend is to create an inventory of the data that you are tracking already, documented, and a procedure for producing a copy of the data and erasing the data should it be requested. Derek, you've worked with clients implementing these measures. How difficult are they to implement?
These first set of measures aren't that difficult. As we've been working with clients, obviously we've been telling them to, obviously have their privacy policy approved by their own legal counsel.
Mm-hmm.
Some of them are taking it a step further and putting an alert on their homepage saying we use cookies to track your behavior and things like that, and having the person, click OK, just to for that extra measure of safeness. And like we said earlier, that second piece is creating that inventory of data. So should someone request it or want to be deleted, you have it ready.
Yep.
It's not, for most organizations, it's not a complicated task. It's usually a cross-team functional group.
Yep.
You need marketing involved, so you can find all those marketing lists and where you're storing information in marketing automation. You probably need sales involved, so you can look into your CRM and see what kind of data you have there. And you might also need your web team involved to see if you're tracking information in the CMS or your website, things like that. But once you kind of identify all those different points, it's just a matter of kind of going in there, identifying the information you have, and putting it in a spreadsheet or somewhere that you have it readily available.
Excellent. So in summary, we recommend an updated privacy policy, a documented inventory of data that you track and keep on site visitors, a documented procedure for furnishing a copy of the data upon request, and a documented procedure for erasing the data upon request. Derek and Paul, as I look to see if we have any questions, any further recommendations you would like to add there?
I think we've pretty much covered it. I guess, like I said, the biggest thing, the first step is to make sure your privacy policy has been reviewed by your own attorney, and make sure that you feel comfortable that it's going to meet the requirements of, again, unambiguous consent, right to be forgotten, and again, what Derek has pointed out, what you can and can't do with disabling cookies or allowing cookies to be collected. But other than that, I think that's, and then obviously you have a data breach, then obviously that's a whole different argument to make sure you're responsive and you know what your duties are going to be and you can't just sit on it.
Excellent. And now we do have a question that came through. The question here is, my website is US based, but there's nothing preventing someone from the EU accessing and or requesting more information, completing a contact form, for example. Am I applicable to the GDPR?
The answer is yes.
Yes, yeah.
It's an easy answer. And again, only that person's going to have to make a decision how likely that's going to occur and what they're actually selling or what they're actually providing through their website.
Yep.
But I think it's something to think about, that it's not that expensive to make sure you're compliant as opposed to hoping you're not going to have an issue down the road.
That's correct.
I guess the only other thing you could theoretically do, which I can't imagine anybody ever doing, is saying we're never going to accept anything from the EU, but I don't know why you want to shut yourself off from that part of the world.
Yeah.
So in my mind, I think you're basically...
Basic answer is yes.
Yeah, and again, I don't think you have to overcomplicate it. In this case, just document where that contact form is going, where the information is saved, and have a means of deleting it should the person ask.
Exactly.
Yep.
It's pretty simple.
Yeah.
Excellent. Best of luck to everyone, and thank you so much for joining us today.